Hello everybody, it's Chris Clark with discgolf.law.
The lawsuit against MCCEASE LLC has been dismissed.
Many of you may already be familiar with the facts of this case. The plaintiff, Mr. Toenjes, was hit by a disc while playing a tournament at the Grand Canyon course and claimed to have been injured. Mr. Toenjes sued MCCEASE, that is the company co-owned by Paul McBeth and Dylan Cease, for damages, essentially saying that his injuries were attributable to MCCEASE having been negligent. Now, when we last gave you the latest information about this case, it was in what we call the discovery phase, when each party in a lawsuit gathers evidence about the case from the other party. Some examples of discovery: interrogatories, which is essentially just asking the other party to answer questions, requests for documents to be produced. And so both parties, both the plaintiff and the defendant, had served discovery requests on the other party, but neither had responded. In October, MCCEASE's attorneys had grown impatient, waiting for the plaintiff's counsel to respond to these discovery requests. So the attorneys for MCCEASE filed a motion with the court asking it to compel Toenjes and his attorneys to respond to those discovery requests. On October 23rd, the court granted MCCEASE's request and gave the plaintiff 10 days to provide discovery responses. On November 9th, MCCEASE responded to the plaintiff's discovery requests and at the same time asked the court to impose sanctions on Toenjes for not complying with the court's order to respond to MCCEASE's interrogatories and request for the production of documents. On December 1st, the court granted MCCEASE's request for sanctions by dismissing the lawsuit. That was the form of sanction that MCCEASE's attorneys had asked for, and the court granted it. The dismissal was without prejudice. And so what that means is, if he so chooses, Mr. Toenjes is free to file the same claims again. So what happened here? We're not involved with the case in any way, so we can only just see what is publicly available. We can make some guesses and assumptions based on context clues. There are some email communications between the attorneys for each party, but without going into a lot of detail, they don't really reveal too much. As we talk about from time to time, litigation is expensive. Sometimes parties just run out of money. Sometimes parties over time reconsider their claims in light of the time investment and headache involved with litigation. In this case, there was significant public backlash against Mr. Toenjes, and maybe he was ready for this case to just go away and decided to give up or just stop responding. On the other hand, maybe Mr. Toenjes's lawyers dropped the ball. I'm not saying that any of this actually happened, but they're all plausible guesses. The bottom line is that for now, this lawsuit is over. And it seems that it got resolved just in time, because contemporaneously with the dismissal of the lawsuit came an exciting announcement that the 2024 Disc Golf Pro Tour season will officially kick off on Friday, February 23rd with the Florida Open at the Grand Canyon course owned by MCCEASE LLC. Now, the tournament has been renamed. This is some additional exciting news. The new name of this tournament is the Chess.com Invitational, presented by Discraft. Chess.com is the internet's top chess site and one of the largest Disc Golf Pro Tour sponsors that we have seen to date. As we've said before, it still stands. If we get additional information about this case or any of the other cases that we have talked about previously, we'll be sure to come on here and let you know. Let me know what you think about the outcome of this case. Please leave us a comment, like, subscribe to the channel, and thanks for watching.